In today's video, we're going to discuss restrictive covenants from a UK property context. So what is a restrictive covenant? It's a legal limitation that is placed on a property's title deeds, often by previous owners or developers, that restrict what the owner can do with that property. They are very common in leasehold properties, more so than freehold properties, and typically cover issues such as building restrictions, property alterations, business use, noise, and potentially nuisance limits as well. Homeowners or potential future homeowners can find out details of any restrictive covenant through their title deeds or by purchasing the title register from HM Land Registry for a small fee. Breaching a restrictive covenant can lead to legal action or compensation claims, even if the homeowner was unaware of the restriction. Restrictive covenants, also known as post-termination restrictions, these are limitations what restrict what the current owner of any land or property can do. They're a binding agreement between past and present owners. The purpose is usually to maintain character and value of either one sole property or a group of properties, such as an estate or a row of terraces. The key point to note is that regardless of how many times the property changes hands, the future owners will still be bound by the existing restrictive covenant attached to the binding agreement. Now let's explore some examples of restrictive covenants, and are they positive or negative? Well, that will be down to the individual to decide, because a positive restrictive covenant could be an example of a home that needs the external of the property to be painted every 5 years or so. Restrictive covenants that could be viewed as negative, now these could be limits on external modifications. So for instance, the colour of paint allowed to be used on the outside of a property. This could be the location of satellite dishes. It could be as simple as just how you maintain the property externally. And also, of course, limitations on internal renovations without consent. More commonly, you will come across restrictive covenants like running a business from a property, potentially limiting the amount of pets allowed in a home, and often restrictions around causing noise or nuisance to neighbours. So how do you find out if you have a restrictive covenant on your property? So if it's a property that you're interested in purchasing, it would be the responsibility of the conveyancer or the solicitor, or lawyer in this case, to identify and bring any restrictive covenants to the attention of the buyer. It's really important to seek legal advice. If you look into your own title deeds before instructing a solicitor, find a restrictive covenant on there. At that point, you definitely want to consult a legal professional. So what happens if you break or you breach a restrictive covenant? Now, it's important to know that many restrictive covenants are legally enforceable. So if you breach one, and you breach one with the excuse that you didn't know it was in the property deeds, I'm afraid that's just not a valid excuse. So let me give you a hypothetical example. What would happen if you started to add another story to an existing property, but it took that property beyond a height restriction that was detailed in your restrictive covenant? That would be a great example as to you're in breach. If that's the situation that you find yourself in, you may find that you're forced to stop the works, and then you may even be responsible for any compensation losses suffered by any other party as a result of the work that you've carried out. So can you remove a restrictive covenant from a property? Now, many restrictive covenants exist for specific reasons, and they are determined by a party with a say in the matter. So for instance, a property management company of a building would have a say in the matter. The short answer is yes, some of them can be removed, because not all of them will be enforceable. So particularly if it's an unreasonable request or it's an outdated request, then there's every possibility that it won't be held up in court. The best person to check with would be a solicitor, as they will be able to advise you on the validity of a specific restrictive covenant. So in summary, the chances of finding a restrictive covenant on a property in London are quite high. For every 90 properties in London, you're probably going to find a restrictive covenant on at least one of them. Now, you don't need to worry if you do come across one, because if it's been presented to you as a property with a restrictive covenant, that will have been done by a lawyer or a solicitor. If you find one on a property that you've owned for some time and you're about to instruct a solicitor, get those documents to your solicitor. They will check them over for you. They'll be able to guide you on the expectations on the incoming buyer and the questions that may be asked. Are they scary? Do they need to put you off? Absolutely not. But you do want to be fully aware as to what is required of you under that covenant. Thanks for watching.